Welcome to the Canadian Intellectual Property Office's educational video series called Intellectual Property Strategy, the Problem Solver's Guide to Staying Out of Trouble. In these videos, you will learn what an intellectual property strategy is and the steps you can take to develop one for your business. Step 4. Create your plan.
After doing the internal and external IP audits, you have good knowledge about the IP relevant to your business. You have connected the dots between your short, medium, and long-term plans with corresponding IP needs and identified the gaps. Now it's time to decide what you need to do. When deciding on an IP strategy, include your accounting team, budgeting team in your discussions so that you have an idea on the available funding to pursue your goals. The amount of money your organization has will largely influence whether you want to amass a lot of intellectual property assets or few. Often you will need to consult with an IP professional to get a better idea of specific ways and costs of protecting your IP.
Let's talk a little bit more about some of the factors that can determine how you plan to use IP in your business. Of course, the budget is going to be very important in what you will be able to do with your IP. The IP strategy is also a result of your revenue model, how you plan to make money. For example, if you are going to do your own manufacturing and sales of your creation, or if you're planning to partner with a licensee to do this. Let's look at some of the more common goals and what the IP strategy would be. For example, some companies have a business goal to reach market leadership. They file for and enforce their IP rights to block competitor growth. This is called an offensive strategy and usually involves a large IP portfolio and a legal budget to maintain and enforce the rights. Other companies may take a more defensive approach, where their aim is to avoid getting legal disputes by minimizing the risk of infringing on anyone else's IP rights. Here, the IP options will range from inventing around a competitor's patent, circumventing, or obtaining IP rights through licensing. In this case, the emphasis would be on the quality of the IP as opposed to quantity. Some monetize IP mostly through licensing to others. For example, a company could make sure the invention is protected in all key markets and then use combinations of different industrial designs and trademarks to license an invention for different applications or regions. You will manage your IP through contracts and invest in a good relationship with your business partners. Remember, intangible assets such as IP can represent over 90% of a company's value, so IP can also be an important tool to raise capital.
An offensive strategy means maintaining and enforcing a large IP portfolio which can be very costly. There should be significant long-term value for your IP. In a defensive strategy, business-critical ideas and creations are protected. The focus then is to minimize your risk of being legally exposed to an expensive and lengthy lawsuit. But remember that a risk of lawsuit is never zero, and IP can be used by your competitors against you.
What about for startups? Do you have any tips for new and upcoming businesses which might be bootstrapping or low on budget?
Yes, many startups have a hard time receiving funding when their intangibles are not secured by IP rights. Also, many investors won't sign confidentiality contracts, making the situation even trickier. In these situations, it can be important to learn how to talk about your invention without disclosing the business-critical parts. You could, for example, say what the invention can do in terms of its features and results, but not mention how these things are done. Also, acquiring IP rights such as patents can be expensive. But some countries like the US make it possible to initiate the application process without investing heavily upfront. The application can be an important step to give you priority rights and also signal to your investors that you have a plan for IP when you attend a pitching event. In some industries like clean technologies, there's also a way to request expedited examination so you will know sooner if your invention is patentable.
Your IP plan should also reflect the life cycle of your products, so you have a plan for what IP protection you need and when you need it.
Often products and services can be protected by one or more IP rights. For example, unique packaging on a product can be protected both as a trademark and an industrial design. A common way to create brand recognition is to first protect the packaging as an industrial design, and when the IP right expires, the distinctive look of the product is protected as a trademark indefinitely. Patents, copyrights, and industrial designs have a limited lifespan, whereas trademarks and trade secrets can potentially last forever. Also, think about the ways to informally protect your IP. Remember the inventor that wanted to discuss his idea at a conference but didn't have IP yet? In this case, it would probably be a good idea to leave your prototype at home, talk about the performance of your prototype, and only discuss limited details with people who have signed a confidentiality agreement. By keeping it a trade secret, the inventor could still attend the conference and in that way take care of the short-term IP goals. Trade secrets can also be a useful tool in industries where products change fast or are difficult to copy or duplicate.
Yes. At this time, when you're setting the plan for how to bridge your IP gaps, it's also useful to consider the locations where you plan to do business, such as conferences, sales, manufacturing, assembly. IP rights are territorial, so your plan may include protecting IP in other countries. Involve your marketing and business development staff and decide on which countries you have plans to introduce new products and services to. Make a list of which products, trademarks, designs would need to be protected. Many people don't know that Canada has signed international agreements for intellectual property so that it's easier to apply for IP rights abroad. These days, there are online systems to submit and pay for international applications through a single portal. Each country's IP office still examines and grants the IP rights as if you had applied to them directly. You can still apply for IP rights directly with your destination country, but using international systems can save you both time and money and give you some valuable time before you have to pay. So, if you're applying for IP protection in, say, a handful of countries, the total application fees may be lower and are also easier to pay than when you file to multiple countries directly. For patents, the international system also has a benefit of giving you up to 1.5 years of extra time before you have to decide and pay for your application in the countries where you're seeking protection. Each country has its own set of IP laws. They must be followed in the formal IP protection process. Even when using an international application system, each country will examine the international application under its own specific IP laws. You can learn more about IP rights and organizations in CIPO's guides for protecting IP in a range of countries. These guides are available online. Learn more about IP rights of your destination at canada.ca/export-IP.